Hello everyone, Simon here. I'm going to give you a presentation which will summarize the law review article, Fighting the Probate Mafia, a dissection of the probate exception to federal court jurisdiction. Peter Nicolas wrote this article in 2001 and was published in the Southern California Law Review. Here's an overview of the entire presentation. We're going to cover some key definitions. I'm going to go over the summary, give you analysis, and critique the article. I learned a lot of new terms when I read this law review article, so please come back to this slide if at any moment you don't know what something means, and hopefully it's on this. Okay, and I'm going to begin with the introduction. So the author started the article by giving us a hypothetical scenario, which covered a vulnerable woman who lived in Colorado Springs, and she was taken advantage of when she went to buy a car by the car dealership owner who got with his attorney friends, and it ended up getting her to sign a inter vivos trust, which led to her own financial abuse, medical neglect, and she ended up dying. Now, her daughter, who survived, went to sue the car dealer and the attorneys. And she lived in New York City. And the case, this hypothetical case, ended up involving various factors like diversity jurisdiction, federal question jurisdiction, and it ended up going to federal court. She filed it in federal court. However, because of what's called the probate exception, which is a doctrine in federal courts that says that federal courts typically do not they don't have jurisdiction over probate matters. And because this was over the estate, or was at least involved the estate of the woman who died, the federal court ended up having issue with this. So because of the probate exception, what would normally be covered or which normally a federal court would have jurisdiction in a case, they don't, or it's very murky if they do, which is what this article is trying to go after, is the issue of the federal courts trying to understand whether or not they do have jurisdiction in a probate issue, or if they don't. And the article aims to look at the history of that situation, and also at the end it proposes action that could possibly resolve it. So how is the federal court system applying the probate exception today? Well, there was a case in 1946 which laid a lot of the framework for how it is applied currently, and that was Markham v. Allen, which went to the Supreme Court, and it involved U.S. citizens and German legatees. And notice the date, 1946. So at the time, there were laws, federal laws, which regulated how enemies of the state were interacted with our law system. And because that federal law, it was considered a federal question. However, the Supreme Court ended up trying to clarify the federal court's jurisdiction over these probate matters. The lower court followed this over the years, creating various tests that tried to extend on the Supreme Court's logic, but it had issues. For example, sometimes it was applied in different ways to testamentary trusts and inter vivos trusts, and all this led to a lot of confusion and inconsistency. So there's different tests in different lower courts for determining when the probate exception should be applied, and it's caused a lot of issues to the present day. Now, to understand the rest of this article, it's important to understand the argument that supports the probate exception. Why does it exist? Why is it that federal courts can't look at probate matters? Now, we have to look at a long historical view, and that begins with the ecclesiastical court back in England, which was a religious court. And among the issues that the ecclesiastical courts decided were matters related to marriage, civil matters, domestic relations, and the probate of wills. Now, Article 3 of the Constitution and the Judiciary Act both give jurisdiction to the federal courts in cases involving law and equity. Now, the ecclesiastical court had its own jurisdiction that was completely separate from law and equity, according to this argument. And because of the ecclesiastical court, which covers probate, had a separate jurisdiction than what our federal courts are supposed to have, it's believed that that was intentional, and that is why federal courts cannot cover probate issues. What is the scope of federal court subject matter jurisdiction over probate, and what's its history? Well, to begin with, there is heavy criticism of the probate exception. An example of that criticism is its exception in the case of diversity jurisdiction. And I think we can imagine some situations where a court should be involved in a probate issue, deciding who gets what, when a state court could be biased for their own citizens. And it's important to note that Congress grants federal courts their subject matter jurisdiction, but probate matters are never explicitly included or excluded. Now, proponents of the probate exception, as I said in the previous slide, they trace it back to the Judiciary Act and the fact that the ecclesiastical courts covered probate. However, there's an issue with this argument, and that's that probate matters back in England, they were divided not just by the ecclesiastical court, but also the common law and the chancery courts. Each would have their own jurisdiction and often concurrent over different probate issues. So that's really a direct attack on the historical argument. And as an example of that, ecclesiastical and chancery courts both had jurisdiction over suits for legacies. Now, if we look at how it happened in the US during the colonial period regarding probate, is that it varied. Sometimes they would use the traditional English system, and they would look back at how they did it back in England, because many of these people were educated in England. However, and sometimes they did have a unified court that looked at everything. It looked at the ecclesiastical, the common law, the chancery, when they were deciding probate matters. Now, the court has developed various doctrines that govern when a court can decide probate-related matters for the federal courts. And the reason for that is that federal courts can decide some of these probate-adjacent situations. For example, they can look at some situations over trusts. And an example of that doctrine is that the custodial legis doctrine, which resolves some of the jurisdictional conflicts between the state and federal courts, especially regarding trust administrations. And what it does is it prioritizes the first court that looks at the trust matter, so that they have priority in decisions, so that you don't have two courts making two different decisions and having all sorts of confusion. There's also various other doctrines listed here that the author lists and details extensively. And what those do is look at all sorts of different situations when a court can or cannot look at a trust, can make a decision on a trust-related, probate-related matter. But there's a lot of issues with these, because obviously, for one, it's very complicated, and there's all these different tests, all these different situations, and even with all these different tests, they don't even cover all the situations. So it doesn't actually solve the problem, and it leads to a lot of confusion. The author concluded his article by giving us a historical context in that King Edward III actually took away the ecclesiastical court's power to look over estates, because the clergy was taking money from these estates and it was putting right into their own pockets. And the article points out the fact that U.S. probate courts, with their own biases at the state level, they could inadvertently give money to religious groups, just as the ecclesiastical courts did in the past. Now, he continued by basically attacking the idea that federal courts have subject matter jurisdiction, because if they're using this prudential abstention in so many situations, really, are they just trying to avoid their own obligation so that they can unload cases from the federal dockets? And he reemphasized the facts that this could potentially, and probably is, prejudicing out-of-state litigants in many cases that should be diversity cases in federal court. And again, he attacked the very historical argument that tries to uphold the probate exception, in that back in the 18th century, English courts of equity and common law did have jurisdiction over these probate matters. And they looked at trusts and wills, and the federal courts should really reconsider whether this is actually the reason that they're doing this. And instead of expanding prudential abstention, they should be limiting it. And finally, if courts aren't going to actually change what they're doing, and they're going to continue to ignore these cases that they should be looking at, then it may be up to Congress to actually pass the legislative acts that address these jurisdictional issues. For my analysis on the article, I agree with the author that Congress should legislate an action that actually solves the issue. Should probate exception continue? If so, what are the left and right limits of federal and state courts? And whether or not, or if it shouldn't continue at all. And I think Congress is uniquely positioned that they can do that. I did do some additional research. Because this article came out in 2001, I wanted to find out if there's been any development on the probate exception. And there's actually a very famous case that I think a lot of us have probably heard of. That's Marshall v. Marshall. And that was the case where Anna Nicole Smith actually, who had a trust, or was supposed to be a trust that was set up for her, and the Supreme Court ended up ruling in her favor. However, the reason the Supreme Court took that case is they wanted to develop the probate exception, but it actually has not lowered the confusion, and there's still a lot of issues and confusion around the probate exception. I do have a little bit of criticism of the article, or I should say critique. Positively, I thought it did a really good job at highlighting the issue. It did demonstrate that the probate exception is an issue and all the complexities behind it. It's incredibly complex, and it did a good job of showing that. And it also showed all the considerations that go into the probate exception, involving trusts and these intersecting federal and state laws, all these doctrines that apply in so many different probate-related issues, and sometimes they don't. And it did a good job at really showing the chaos that's involved in the probate exception. I wrote here, I have some unintellectual criticism, and I think that's more that I am brand new to reading a law review article, and it's clearly not targeted at me because I had a very hard time following it. It was 70 pages long, and I spent way longer than I should have spent on each page. And I think law review articles are honestly too long. I was reading a little bit about it. There is a movement to try and shorten them. Its organization structure, I felt like it jumped between issues really quickly, and it was hard to actually understand what the point of it was, because sometimes I was like, is it explaining what the probate exception is and all the history and doctrine, or is it trying to find a solution about it? And frankly, I'm still unsure. It could have been way more concise, and to actually understand the probate exception, I had to go to a lot of outside sources. I read Harvard Law Review articles that I thought were much clearer than it was, and it's, I wrote here, it wasn't made for regular people like me. Everyone, I included the citation for the article here at the bottom, and I want to thank you for listening to me. I know it was a very difficult topic. Believe me, I struggled with it, but I appreciate you sticking with me.